For drawing of degree. Formal order for private. This was disposed of. This is the judgment. Other orders from orders for private. Sorry, I'm not getting one set up. That cannot be drawn unless there is a formal. Monday. Monday. There is a very thing. Huh? At the top, you can have it at the top. To be mentioned. That will come on Monday. Coming Monday, under the heading to be mentioned, let the opposite side be informed.
Lordship, may I be permitted to mention a matter? It is appearing in the today's list as item number 220. Your Lordship has directed us to file informal paper book. We have filed the paper book. Your Lordship may kindly fix a date so that it can be taken up, Your Lordship.
What is the issue?
Your Lordship, it is a review.
So it will come. Wait. Yes. All.
Item number 1.
For the petition in this matter, on the last occasion, we had given a affidavit of service, but since we are not satisfied with the track report, we immediately contacted the postal department and we issued the letter on the same day to the director of the postal services. There were an exchange of communications, and they have confirmed that the delivery of the state applications which have been served upon the restaurant. So it is there with me. If you can kindly go through it, it will be. If you can kindly give your concurrence, then if required, then I can submit affidavit of service with these papers also.
The learned advocate for the union.
It-
Two. There is no doubt. Oh, this matter was taken up yesterday.
Yes.
Yesterday, I could not say. The tribunal did not. That point was not taken in the writ petition matter. That is my fault.
You filed a opposition before the reply before the tribunal.
You have filed, my lord, at page 72, my lord, starts at the 70. No.
No, 70.
Position is starts with 70. The relevant portions, my lord, is paragraph 6, my lord, 70 starts from page 71. Yes, I have placed it, His Lordship.
Oh, yes.
If His Lordship takes page 72, 6.3, that a departmental proceedings was started against the applicant under so and so, censure imposed so and so. The applicant made an appeal against the said order dated so and so, which is still pending. And in this reply, my lord, he has not merely said, my lord, certain person has been promoted and all these things. But
No,
what
but this proceeding is of 21.
21, my lord.
He is claiming the promotion from 17.
And 2022, another order was passed, my lord. He has not challenged that. Has yesterday, Lordship has.
Where is that order?
That order is at page, my lord. Page 88, my lord.
And on what ground the tribunal has rejected the claim?
Tribunal has said, my lord, last paragraph, lordship will find, my lord. It is a well accepted administrative norm that a past period of an employee constitutes a very significant factor while considering him for an promotion. The authority has the legitimacy to decide to withhold any promotion if they are not satisfied with his past performance, as manifest in the entries records in the SARs/ACRs. Even a single adverse remark is likely to jeopardize the opportunity for such promotion. Therefore, this tribunal is of the opinion that the respondent authority has taken a valid and correct decision while withholding his promotion to the past post of chief engineer.
So if we remember correctly, he was saying that only after you filed the reply, he knew that some adverse entry has been passed.
Is it believable, my lord, that he is in the service, my lord? He don't know that any adverse remarks and a show cause was issued against him, and he preferred an appeal from that.
Which show cause?
It appears from my lord, page 72, my lord, that a departmental
Yes, that is the show cause, or it is a charge memo? It's a charge memo.
But prior there is some communications with him.
Finally,
definitely
censure has also been imposed.
And he has challenged that, my lord. So, my lord, is it not 17, my lord? He is asking promotion.
Yes, yes.
That was that in the year of 2012 when the departmental posting was initiated. 82. When the departmental posting was initiated, it's true. But my position of the department, page 9. And the other mistakes. But there concentration of P that amplified submitted by such on or withdrawn the penalty of shelter of 50 March 2020 of the department of the terms of the position of revision and breakdown hereby impose and state penalty by the power of according to the referendum stated March 2020, by which the state was and the final order hearing the 50 right, the state was imposed at the completion of the hearing. But the 8th was there.
That is not relevant. That is not relevant. That is after your OA has been disposed of. That is not relevant to the OA's order. This memorandum is of February 25, much after disposal of your OA. So that is not relevant for the OA. How many times you will say the same thing? You have already said that. 25, this order has, this memorandum has been issued. How it is relevant to the tribunal's order passed in 2024 cannot be. It is a subsequent event. It has no bearing on the tribunal's order. Whether this allows you an opportunity to do anything now or not, that is not the issue before this court. Maybe that gives you an opportunity now that now censure is gone. I will claim, we don't know, but that's not in the tribunals. There's nothing to do with the tribunal. Yes, correct, correct. All right. Heard learned advocate for the writ petitioner and the
chief. হাতের কাছে নেমে এসছে।
Yes, that's all. Third learned advocate for the writ petitioner.
Only one side.
Order is passed. Call the next case. Call the next case.
Item number 3.
For the petitioner, madam. I have served all the responding, madam. Petitioners appointed in the year 1981, my lord.
ARSEM. Is he here? Aryan has. Aryan is here. Ask him to. Yeah.
Yes, my lord. Petitioner was appointed in the year 1981 as a KP. Retired from service, my lord, 30th November 2013, my lord. But till date, my lord, the pension was not sanctioned, my lord. This is a third litigation. 2017 order was passed. The responding authority considered and allowed, and my lord, granted, my lord, the pension is entitled to. Thereafter, no steps was taken. Again, my lord, 2021, one OA application was again filed, my lord. The again OA was allowed, and my lord, the respondent authority calculated the same, but they have not taken any steps to disburse the same, my lord. Again, my lord, 2013, 2023, my lord, again file a OA application, my lord, to direction upon the respondent number 7, my lord, to approve and send the same to the respondent number 8, my lord, for the issue, my lord, the pension payment order, my lord. But till date, no, they have not issued any, my lord. The learned tribunal, my lord, day to day, my lord, adjourn the matter only on the bench is not available, my lord. Kindly see the all order I am annexed, my lord. My lord, I am from already, my lord, 22. My lord, 12 we are already passed, my lord. I am not color of money, my lord. I am আরেকটা দিয়েছি আমি।
Copy this. আসছে না কেন?
My lord, if your lordship kindly have a look at my lord page number, because so far my lord, the uh, first writ petition was filed, there was an order, first way was filed, there was an order directing my lord, the Director of Agriculture Department to look into the matter to pass it is an order. Now my lord, lordship kindly have a look at page number 57.
That is not the direction. The direction is very specific. Come to page 69.
I am coming to that 69 letter.
Yes.
But first 57,
Yes.
that in terms of the direction passed in the first way, my lord, the order passed by the authority concerned. 57, lordship, kindly come to me.
Pension
Yes.
papers are
I am
not
on that.
available.
I am not also on that. He is
Come to
entitled.
69. His last order is page 69. You read what it says.
He said that retired in 2013, but still pending because of the fact. One of the reason is that at page 57, admitted fact, he admitted before the authority that he submitted his pension papers all in, my lord, 2019, only in 2019. And my lord, despite several, my lord, requests to him from 2013 and onwards, he said that he received those, my lord, intimation, but he did not respond to that. Now, in any event, it appears that in 2019, he filed all his papers, submitted papers. After that, my lord, kindly come to now, my lord, page number 65 to 69. Now, my lord, after that, my lord, the process, it was, my lord, it was rolled, and my lord, now the question is, lordship, kindly come to, my lord, page number, the three orders, 78, 79 page, and
This order which is
now
passed
there is,
in
may I-
OA number 176 of 21, 4 years have lapsed. That order was passed in October 21.
yes,
We are in October 25.
my lord, kindly come to, my lord,
4 years has not been enough to forward his pension papers.
my lord, subsequent to that, lordship, kindly come to, my lord, page number 78 and onwards. 78, page number 78.
Yes.
Page studio. Number 7, page number 78. This is the order passed in the third way of 25th of April. Responding to prayer A of this application, which is for submission of pension proposal for approval of Finance Department, Mrs. Agarwal submits for the state that such a proposal has already been submitted. So that proposal submitted, prayer B, which is direction to the Finance Department for approval of such proposal, he submits such proposal has not yet been decided. But the latter order after 25th of April, my lord, kindly come to the next page 79. It is, my lord, dated 3rd of July 2024. The state submits that in the meanwhile, the views of the Finance Department have been obtained. Pension proposal will be submitted before the Principal Accountant General. Naturally, in due course of time, then the writ petition or the applicant in way submits, since the prayer of this applicant for sanctioning of the pension has not yet been fulfilled, matter be heard, and state respondents to file a copy of the proposal, matter to appear on 9th December. Then the last order passed in that way, which is pending on 9th December 24 at page number 80. The second paragraph.
Yes, for reconstructing the.
Yes. Now, I have to take instruction at which stage, whether reconstructed or not. I think already done, but because of I received it, my lord, the forwarding letter 27th of October.
We were listening to try to understand what will be your submission. Why you are referring to so many documents? The only thing is, what have you done?
May I tell?
That is the only thing.
May I tell? The present status, I have to take instruction.
Exactly.
Today is the reopening day.
Exactly. That's what we are saying. Why you are referring to so many documents?
Kindly take it, my lord, the next week. I shall take instruction that what
Item 4.
আমি রেসপন্ডেন্ট 1 to 15 আর কারা আছে 26 এর নো নো জেলা পরিষদ আই ক্যানট অ্যাপিয়ার preparing for the respondent number 1 to 15.
It's a relatively cool weather today. There is yes.
I don't know what page heater. No, I have to কোনো মার্কে সবাইকে সাজেস্ট করা আছে
So you are not representing all the respondents. Has any notice been served on them?
জেলা পরিষদ সব এভরিবডি
Has it been served, Mr. Bhattacharya? Already? And were they represented on any date?
The matter will be heard on.
somebody is appearing
Yes, yes.
oh somebody is appearing
Yes, there are about 50 respondents.
16 is the Jalpaiguri 17 Howrah 18
All the
Nadia,
district Jila
19
Parishads are part.
Purbo Bardhaman, 20 Bankura,
So the tribunal has found that the OA is not maintainable.
only
What was the relief claimed before the OA?
But we claim certainly that the financial benefit as per the government's approval. Now the tribunal comes to conclude we are not the government employee. That is the issue to be decided by your lordship, whether we are government employee or not. According to me, I am covered by the Supreme Court judgment that the panchayat employees are government employees.
Yes, that judgment you had shown us. No, we are just trying to see what is the relief in the OA.
Yes, kindly put a turn to page 69. Here in the implement the circular for career advancement scheme and to treat the applicants as government servants.
Oh, so you want to be treated as government servants.
Yes.
That is your prayer.
That's my prayer.
That means you are not government servants. Therefore, you want to be treated as government servants.
According to us, we are government servants, therefore we should treat them.
No, because what are these two orders? 17/8/2009 and 1/2/19.
Yes, that I shall please. Let kindly come to me, Lord, the order of appointments at page 74, creation of post. Page 74.
In 2006, it was created with approval of the finance department. The commissioner of the department was held to be the appointing authority. The concept was that perhaps there is a term I forget. I'm sorry.
They have created a cadre.
They are called.
Panchayat service cadres. That is also will
No, they are to oversee which two persons.
Lordship probably has gone through page 74. Lordship may be pleased to go through page 76 also.
Yes, Shishu Shiksha Karma Suchis
Yes.
and Madhyamik Shiksha Karma Suchis. These are the two kind of persons imparting education at the panchayat level. So it was found that it was considered important to have someone to coordinate the efforts to ensure that the mission is discharged properly. So coordinator was to be appointed. Now the government issued the orders, laid the foundation for appointment. Petitioner was appointed, that we had seen already. Mr. Bhattacharya has placed on the earlier date.
Order controlling authority is the Jala Parishad.
Correct. Correct. Under the Zilla Parishad, that order is consistent from 2006, 2007, 2008. So what are these two orders which have been referred to in the third prayer? C.
17th August 2009, that is at page 69.
69. Come to 188.
131.
Can you please come to 188?
138 and 191.
Can you please come to 188?
And 191.
So this is a order issued by the government saying that this is not a non-government post.
Not a non-government.
This is a non-government post.
Then kindly come to the page 191.
Yes.
191, yes. But this was taken note of by the London Tribunal, still pending by humble submission.
No, there are two. Mr. Bhattacharya, please see 188 first. Serial 1 at 188.
188.
Because that is an earlier order.
The clarification regarding the post and service status of assistant coordinator,
Yes.
since renamed as assistant coordinator education.
Now, point 1.
To say that since issuance of this department memo, naming recruitment named as so and so, some points relating to the post and service status have been raised by different Jilla Parishad. On examination of all points, a clarificatory statement is given. As
Given. Now, 1 is important.
yes. These posts in non-government
Non-government.
born in the third Panchayat cadre under Jilla Parishad so and so, appointing authority is the commissioner. Therefore, these two runs contrary.
So whatever it is, what they are saying is it is part of the local self-government, but the appointing authority is the commissioner.
And then kindly the next one. The controlling authority is the commissioner.
Same.
And the service of the assistant coordinator education are transferable
Inter-Zilla, yes.
SCR of the assistant coordinator shall be initiated by AEO, Jilla Parishad, countersigned by the executive officer, that is the district magistrate, and accepted by commissioner. The ultimate control lies with the commissioner. The matter of leave so and so, the extent norms and procedure being followed in case of other employees shall be applicable.
Is there any? Yes, sorry. Yes.
Then kindly turn to the page 191. The question of the career advancement scheme benefit was under consideration by the department. They say the post of assistant education is a non-government post in the state panchayat cadre so and so so and so. The employees of Jilla Parishad are entitled to 10 years and 20 years cash benefit. Hence, the question of providing 8 years cash benefit to the assistant coordinator does not arise as per government order so and so. In respect of the provident for the employees of the panchayat, form of ledger shall be maintained by the accounts officer so and so so and so and so. And then say, well, this is the order. It should be informed. Then page 192, this order was kept in abeyance.
Which order? A 191.
191.
By which order?
Next page. Page 192. By order date 12 February 19. Miller Lordship would kindly take the trouble to come below the concluding paragraph. In the above circumstance, I'm not reading the entire thing. I am directed to inform you that the matter is under active consideration of both the department and the directorate. Hence, the implementation of the order issued by the Commission on 1st February may please be kept in abeyance until further order.
So there was the accounts officer was not to take care of the things.
Now, the Lanet Tribunal relies upon 191, and this is my without taking care of 192, where 191 is kept in abeyance by government.
No, but what is kept in abeyance? Paragraph 3 only.
No.
Of 191.
The memo itself.
Yes, but the only thing is in paragraph 3, because a non-government employee has already been stated at page 188, so that finding remains.
That finding remains non-government employee, but at the same time they say they are governed by the Cadre rules created by the government and appointing what is commissioner. That is the point.
Where is the rule under which they are appointed?
That rule Mr. Mukherjee had handed over to us.
97 rules, some rule of 97, if we remember correctly. You have already given.
97. It is Article 8.
Can we proceed in absence of the respondents?
Lordship, give a chance, we shall give him a notice further, then if they
Because
declare.
we would rather take, now it has to be taken up, but too many adjournments have been.
Mr.
Bhattacharya was in some difficulty. He was in parliament. That's why.
Mr. Mukherjee will gladly take this favor, because they think that intimate all the Jilla Parishads.
How I can I'm not the petitioner.
You cannot, you can intimate the commissioner.
That
You can intimate the commissioner.
Yeah, I
You need not intimate all the Zilla Parishads. You can intimate the commissioner.
matter has been the key.
He is the person under whom these persons are appointed. They are posted at the parishad, but they are actually servants of the commissioner.
There are 3 tier of panchayat. Gram panchayat.
Commissioner must be a respondent herein.
Yes. The first, 3 tier panchayat, gram panchayat, panchayat samiti, then Jila Parishad.
That you have informed. We are aware. On the first time we were not aware. I was not aware, speaking for myself. Now I am aware. But the issue is, let them be ensured that they are represented somehow. See, they cannot take any stand different from you.
Yes.
Whatever stand you take, whatever stand
They are elected body.
One by the rule.
they have nothing to do with this appointment of this assistant coordinator. This is all done by you, the commissioner.
Commissioner, but appointee selection committee is made by the Jila Parishad.
Correct. So that's not an issue. The point is their status. What is their status? Regarding their status, what Zilla Parishad will say? Because the records show that they have been appointed by the commissioner. They are being placed in a pay scale. Their services is transferable from one Zilla Parishad to the other.
ACR is controlled by the commissioner.
ACR is written by the commissioner. He is correct. All these facts are there. Plus, the creation of post is with concurrence of the finance department.
Every post has to be created by the government.
Which post?
Every
Which
post.
post?
But whatever be the post, area panchayat, gram panchayat could be panchayat worker, all the post has to be created by the government. Then rule has to be framed by the panchayat act. Not a single post in a gram panchayat or panchayat samiti or Jila Parishad cannot be created by the Jila Parishad. Whatever their proposal, they will send to the government through commissioner. Argument হবে তখন
How do you propose to ensure that they will appear, or some?
The commissioner will intimate all the Jilla Parishad, the matter.
No, if Mr. Bhattacharya Junior can communicate.
আরে তোর communication শুনবি যে এটা চিঠি পাঠাবে অফিস
For me also.
So I say that it is convenient for commissioner to intimate.
Yes, we think so. He can just by one communication he can inform everyone.
Data is not open that will reach when they receive.
Plus, you are being instructed that somebody has represented them on an earlier date. Only one person is appearing.
Another person appeared for another Jilla Parishad, I am told, তাই তো?
And AG Bengal.
Huh?
And AG Bengal, respond number 46.
Respond number 2.
But I cannot communicate. AG Bengal.
তা ভুল লিখেছে।
I can respond number 46.
এই
I cannot.
উত্তর ইনপুট দুনিয়া।
No.
হ্যাঁ? জেলা পরিষদ।
But what I cannot appear for on behalf of I respond number 46.
46?
6. That is page 40.
State government of
No. AG Bengal.
no. Government of West Bengal.
The government of West Bengal, AG Bengal, West Bengal is the central government.
No, it can't be government of West Bengal. AG has is central government.
We have served the mission serving it. For the AG is concerned, we shall serve.
You serve, and as regards the other respondents, the commissioner is respondent number.
3.
Respondent number 2. Let him ensure.
That is intimate. Otherwise, later on, they will come and say we were not intimated.
No, but whether earlier the notice has been served on them,
The bill of service file, that's okay.
is that recorded in any order?
এটা কথা না, তুমি ফাইল করেছো কি? Official service. দেখে নাও।
Is that recorded in any order?
I'm not sure that
You want to check?
can be records. খুঁজে পাবে কি করে? প্রথম লিখ থাকে। Record. ওইটা কোনো কথা না, তুমি সার্ভিস অ্যাপ্লাই করলো কি করে, দ্যাটস ডিফারেন্ট।
Because if earlier it has not been served, you should serve once.
Petition.
So Mukherjee, please have a look at order of 12/3/25. Please have a look at the order of 12/3/25.
Yes, the official service is there. I stand correct, it was not served.
So then serve once. You please serve. At the simultaneously, we will request the commissioner to send intimation to them.
Be expediting the matter. Okay? আমরা
So copy has to be served.
Correct,
Can
correct.
serve the copy.
Correct. No, he will. How many respondents are there?
Let's 2 or 3 appear, check করে দাও।
2 and 3 have appeared, and you are appearing for which respondent? 2, 3, 36.
I'm appearing with respondent 1 to 15.
1 to 15 and 36 are represented.
5:30 start করতে।
So for the remaining, you serve notice, and will you file a paper book that will facilitate?
And 46 is the AG Bengal.
26, 27 তুই apply করছিস।
No.
Again,
I can mission director, I cannot appear. Mission director, a autonomous body.
board না ADM,
ADM I can appear.
তাই তো? 26 সালটা
Yeah. 26 I can appear, 27.
26 to 35.
ADM
26 to 35. 23.
জেলা পরিষদ গুলো আমি দিয়ে দিচ্ছি, বারবার তুই apply করছিস। তার মিশন স্টাফে জেলা পরিষদ।
Just a minute. 26 to 35 you are representing, and 1 to 15 you are representing.
And 46 has to be served.
Yes. You are representing 1 to 15,
Yes.
and 26 to 35. He is representing 23.
Yes.
So the remaining have to be served
থেকে সাফ করে দাও।
when the matter is called on today.
Item number 5.
Item 5, 6, 7, my lord. Yes, sir. Item number 5, 6, 7, my lord, affidavit in opposition. I am going to file in opposition, my lord. That is ready, one not affirm, my lord. Kindly one day accommodate. You are filing affidavit in opposition.
আপনি তো petitioner.
Sorry, reply.
Of
How much time you want? 1 week, my lord.
But on the last occasion, so Manad, we brought it to the notice of this honorable bench that Manad, already we have filed an SLP. We are having this SLP Manad,
These are the
land losers.
oh,
So Manad, kindly keep this all the matters Manad, after but X months vacations in January. In the meantime, I think so only we got the diary numbers.
no, diary number is there since long, but
And,
you are not taking any steps.
Told Manad, the SLP would be listed within 2 weeks. So it will take some time to get it admitted or rejected, whatever may be.
So let the matters now come in the first week of December, we will see.
As it is.
Give the diary number.
Yes.
Certain order.
Reply দিল জমা দেয়নি তো?
Definitely.
Nine. Ninth people. Item number 6. Oh, 7. Item number 8. 6, 7, 8 in petty order. 187. 9, 10, 11, 12, 13, 14, 15, 16,
Similar matter, 10 to 15 matter. The petitioner is not appearing in since long because this is the one. Yes, madam. Not today.
17, 18, 19, 20, 21, 21 টা দেখুন 305
I have heard one resolution is there. I have heard just now one resolution is there not to pass any adverse order.
Adverse order, we are hearing you. Correspondent is appearing. Huh.
First wave was filed before the tribunal, challenging the charge sheet.
Challenging charge sheet.
Charge sheet. And that was heard by the learned division bench of the learned tribunal. And thereafter, that was dismissed. Thereafter, again, at that time, challenging the charge sheet wave was filed. Thereafter,
MA was filed.
original application was filed before the tribunal.
Yes, charge sheet was
Challenging the
challenged.
charge sheet.
Division bench considered the matter.
Division bench considered the matter. And ultimately, the matter was dismissed. Challenging that, writ petition was filed. That was again, demanded back before the tribunal. But, that was heard by the learned single bench, the judicial member. That was my first point, my lord. So when, my lord, the matter was, and thereafter, my lord, that another was filed and that was also admitted. That way was admitted by the Honorable Division Bench of the Tribunal, but finally disposed of by the learned single member of the bench. And my lord, that the first wave was, my lord, the dismissed, holding that the second charge sheet was valid. Two charge sheet was issued, my lord. The first was first charge sheet, thereafter, my lord, the withdrawing the second charge sheet. And my lord, the Honorable Tribunal was held that the second charge sheet is valid. My lord, but my lord, in the second way, that that was interfered
Second charge memo was also interfered
by the Honorable single member of the bench of the tribunal.
So why the single member cannot hear it?
Yes. If, my lord, there is any, kindly consider, my lord, that first matter was heard by the division bench. And my lord, if there is any complicated question of law is involved touching with the constitution, that matter should be heard by the Honorable Division Bench.
Any
And my lord,
complicated matter has to be heard by the division bench.
not any matter, my lord.
Then
My submission is this, my lord, if there is any complicated question of law is involved. My lord,
so let us see the provision.
yes, my lord, that last judgment of our division
His lordship,
also says that. My
His
lord,
lordship Justice Basak's judgment is there. Yes.
initially, my lord, I also appeared in this matter. Initially, that was, my lord, that remanded back. My lord, thereafter, the Central Administrative Tribunal itself, my lord, filed a review application.
Correct. Yes.
Review application. In the review application, I was not appeared, but my lord, that was, my lord, the decision, my lord. My lord, that was, my lord, also relying upon the holding the El Chandakumar's, my lord. The El Chandakumar,
Holding?
El Chandakumar's, that is the constitution bench.
Correct.
That
Where the virus of the statute is an issue or the competence of the tribunal itself, then
yes.
otherwise there is no requirement that it has to be heard by a division bench. Section 5, it enables the chairman to allocate the business.
Yes, my lord, kindly consider that this is a very voluminous judgment, considering that the how many judgment of the various courts. So, my lord, there should have, my lord, the complicated question of law is involved. My lord,
So therefore, first thing is there any proposition that all complicated issues have to be placed before a division bench? If so, which is a complicated issue, who will decide?
so, my lord, that was to be at first decided by the learned tribunal whether there was any complicated question.
But where is the basis for such a submission? This submission either has to be founded on some provision in the Act, rules, or L. Chandra Kumar.
My lord, El Chandakumar, along with, my lord, that latest judgment of our in the review of our judgment.
So we'll see just now.
Okay.
So the relevant provision is 5, 6, 5 subsection 6.
My lord, another point is there, my lord, that in railway disciplinary appeal, there is a provision of appeal. But without preferring any departmental appeal, my lord, they have straightway filed the original application before the tribunal.
No, appeal will arise only when there is a punishment. You are saying we have not seen it. You are saying they have challenged the charge memo. If
Charge memo in the first original application.
yes,
Thereafter, my lord, that was, my lord, dismissed. That original application was dismissed by the Honorable Division Bench of the tribunal. Challenging that, they preferred an writ petition. And during the time of the pendency of the writ petition, my lord, that final order was passed.
oh. But you said second charge memo was issued also.
This one.
So after the final order was
After
passed,
the final order passed, my
the
lord,
matter was remitted to the tribunal.
not remanded, liberty was granted to take appropriate steps, my lord, by this honorable.
Where is the order of this court? This court's order, let us.
Court order is, my lord, at page my lord, page 230, my lord. My lord, relevant portion is page 234, my lord. From 234. Of the order of the tribunal do not find that the tribunal has made any observation on the issue as to whether the second charge sheet issued to the petitioner without giving reasons for withdrawal of the first is valid. In fact, the tribunal has observed as such, it cannot be denied that the respondent have totally ignored the provision of the law and not mentioned any reasons for withdrawal of the first charge memo. The petitioner therefore feels, however, it will be open to the petitioner to challenge the order of the dismissal against him. The petitioner can raise all contents before the tribunal, including the issue as to whether they have been issued without mentioning sufficient reasons for withdrawal of the earlier practice. The tribunal shall decide the applicant uninfluenced by any observation made by it in its decision in way number such and such, dated 25th July 20. My lord, that was the order of the first of the
This order was not challenged by anyone. The order of the High Court was not challenged by. So can you raise an issue regarding non-exhaustion of the statutory appeal? The order, please see page 234, last paragraph. If you have not challenged this order, then whether it is open to you to raise such an issue?
However, it will be open to the petitioner to challenge the order of dismissal passed against him. The petitioner for contention
Before the tribunal, including the issue as to whether the second charge memo could have been issued. So therefore,
sufficient reasons withdrawal of the earlier charge, the tribunal shall decide that. At that time, whether that point was raised or not, that was not, there was no opportunity of this honorable court in that earlier order to consider that there was a provision of appeal is there.
oh,
Because
you were there. You were there.
the
You
that
were
was-
there.
that
It is
point
not
was-
passed in your absence. You were represented. That's why we asked you, did you challenge the order?
in that matter, railway was represented anyhow. I was not there. Any advocate or yes, ma'am.
You were there.
Yes.
Mr. So-and-so was not there, but you were there.
And the record is also shows that man.
Yes, because the name of the learned advocate is appearing in the first page. And obviously, this court has given him liberty to go to the tribunal because it has allowed him to raise an issue regarding the charge memo also. Therefore, it has been liberty has been granted to move before the tribunal. If the charge memo is not in issue, then appeal could have been referred. If charge memo is in issue, then the tribunal
Charge memo along with the my lord, the final
Correct.
order of the disciplinary.
final is this. So if the tribunal is persuaded on the grounds raised to assail the charge memo, everything will fall. There is no question of appeal. If not, then
And my lord, the charge was against the petition applicant, my lord. He was, my lord, continuing his service with a fake, my lord, the
he had
appointment.
obtained appointment on fake documents. Charge memo was issued. He was proceeded against. He moved the tribunal during pendency of the proceeding. Inquiry report was submitted. Issue
Inquiry-
was said that why don't you go and make your representation before the disciplinary authority. In the meantime, this was also done. Finally, removal order was passed. At that juncture, the High Court said now that since everything is over, yet in the meantime, before proceeding on the charge memo, a second charge memo, that charge memo was withdrawn and second charge memo was issued at the very initial stage. So on the second charge memo, everything proceeded. He said charge memo could not have been withdrawn without any reason.
Charge memo was withdrawn.
Charge memo was withdrawn. Petitioner said that charge memo could not have been withdrawn without any reason. Why a fresh charge memo was issued? Therefore, the High Court said you can raise this issue. Go before the tribunal. Please see.
Consider the fact.
Come to page 232. 232.
And moved on August 22. Nobody appears before the respondent on that day. However, we direct that the earlier order of the tribunal not to impose any penalty should continue for a week from the date of an order. Our order. Therefore, continued for a week from 3rd August 2012. The petitioner did not have the stay extended. Instead, when the matter reached on 21st August 2012, we were informed that an order was passed based on the second charge sheet issued to him on 20th October 2006, as there was a dispute as to whether the service of the order of all was inflicted on the petitioner. We direct that the order should not be given effect for a period of 2 weeks. The matter was listed on 5th September 2012, when we were informed that the removal order had been passed and was served on the petitioner. The service was effective on 24th August 2012.
Now, next paragraph is important.
Submitted on behalf of the petitioner that the tribunal has urged in dismissing the original application as no issues has been issuing the fresh
For issuing a fresh charge memo.
giving the same charge.
Yes.
Why we give the earlier one? After submitting that on behalf of the petitioner that the priority of each
And therefore, at page 234, last paragraph, the liberty has been granted to a sale.
that matter, railway was also represented.
Therefore, that point, whether you can urge now that he has not exhausted the remedy of appeal, that is it. Anyway, that is a point you have urged. The other point is regarding single judge.
Kindly see. Original first way, that is way number 718 of 2008, that is page 80, my lord.
Page
80. And my lord, the last page is 93. That was, my lord, that is by the division bench of the tribunal. Then, my lord, kindly see the second way.
Where is the order passed by the division bench? So that was the order under challenge in the writ proceeding, the order of which we have just read.
And thereafter, my lord,
OS 718 of 2008. Where is the order passed?
that order was challenged in that writ petition.
So where is that order? Order of 25th July 2012 passed in OS 718 of
My
2000.
lord, that is at page 80.
Oh, that is at 80.
My lord, I want to show, my lord, after that, when the second way was also filed, that was initially, my lord, admitted by the division bench of the tribunal. My lord, that is page 101, my lord. Page 101.
No, that is not required to be shown. Nobody is disputing this fact.
Yes,
The point is, if it was admitted by a division bench, heard by a single bench, what is the infirmity? Why it is wrong? Why such a course is not sustainable?
And respectful submission is, my lord, that initially that way was admitted by the honorable division bench of the tribunal, the impugned way. That is way number, my lord, 17 of 2015. Way number 1381 of 2013. My lord, page 101, my lord.
1381 of 13.
Page 101.
Yes.
Kindly see the bottom portion, that was, my lord, entertained by the division bench. 101.
No. Therefore, we are saying there is no dispute on this fact. We are asking you why it is wrong. What is the infirmity if it was admitted by a division bench, heard by a single bench? Why it is not such a course of action is not sustainable? Under which provision?
My lord, that fact of, my lord, the appeal, that the provision of appeal, that was, my lord, not considered.
We ask you apple, you answer about oranges. We are asking you what is the infirmity if a single bench has heard the matter after the division bench had admitted? Why such a course is infirm? It is open to challenge or not sustainable. Why? You have already said that there is no exhaustion of a statutory appeal. We have already seen that. Now this is the other point. So again and again we are asking you why it is not sustainable.
My lord, in this matter, my lord, the railway servant disciplinary appeal rule was involved. And my lord, that was, my lord, the question of the constituency of this involved in that matter was involved. So, my lord, according to the division bench decision of our High Court as well as the L. Chandrakumar's
So let us see. Let us come to that.
my
Let
lord,
us see the
kindly
judgments.
judgment of the L. Chandrakumar, my lord.
Yes, let us see. Seven. Yes. Paragraph 98.
Kindly, I want to please, my lord, the relevant paragraph from paragraph 78 and
78. That's not relevant. Your submission is that it is to be placed before a division bench. The relevant paragraph is paragraph 98.
uh, 6 and 19 that was discussed in this matter.
But what is the order of the apex court? Come to page paragraph 98. See what the Supreme Court says. Where interpretation of a statutory provision is involved or the virus is involved, then it has to be placed before a division bench. Please read paragraph 98. Yes, that is where 5, 6 and 5, 2.
Analyze the issue of constitutional validity of section 5 subsection 6 of the Act.
So prior to this, the validity has been examined. Yes.
Now, on this aspect, through the virus of the provision was not in question in Dr. Mohabal Ram's case. We believe that the approach adopted in that case, the relevant portion of which has been extracted in the first part of the judgment, is incorrect since it harmoniously resolved the manner in which section 5 and 5 section 6 can operate together. We wish to
Yes, we wish. This is the most important.
make it clear that where a question involving the interpretation of a statutory provisions
Involving interpretation of statute. Yes, then
under the railway service statutory provision or rule arises or a consideration of the bench administrative tribunal. The provision of section 5(6) will automatically apply or the member concerned shall refer the matter to the bench of at least 2 members.
2 members. Yes. One of whom must be a judicial member. Yes.
Why matter? Single member, that That is
So every departmental proceeding according to you has to go to a division bench.
that is not my submission.
So the apex court says where interpretation of the rule vis-a-vis the constitution is involved, then it has to be placed before division bench. You say because action is taken under a rule, it has to be taken before a division bench. Where is the interpretation issue?
Interpretation is that is the Railway Servant Disciplinary Appeal Rules.
There is no interpretation.
When in presence of the provision of the departmental appeal and ignoring that, if the applicant filed the original application challenging the only the order of the disciplinary authority dismissal.
So there is an issue of interpretation, or there is an issue of non-compliance with the rules. Where is the issue of interpretation? Interpretation and non-compliance are the same. Therefore, we said then every departmental proceeding has to go before a division bench. Because there is always an allegation of the non-compliance with the provisions or violation of the provisions. You say statutory appeal remedy has not been availed, so there is violation. So all cases of violation have to be placed before a division bench. If this is the Union of India stand, then we'll record that. The judgment is as clear as daylight. It says interpretation of the rule or statute vis-a-vis the constitution. If that issue arises, the chairman will refer or the bench will refer.
Chairman, I think.
And when did you raise such an objection?
That is to be considered whether the administrative order or an judicial order. When the chairman of the tribunal considering the matter safely, either division bench or the single bench. So that ought to have a judicial order.
Where is that? Everything you are saying as if your concept of righteousness has to prevail.
Apart from this
Where are the provisions requiring such things to be done? Merely because the resultant order is not to your liking, you cannot say that this has to be done and that has to be done. 5(6) is very clear. Therefore, we at the outset we said you read 5(6). You did not want to read. You read 5(6) what it says. Section 5(6). The chairman has the power to allocate the business by making an order in this regard. Whether judicial, administrative, this issue is not there. There is no such issue. It is settled by the apex court decision and you are raising these issues which do not arise for consideration. You have also not raised this issue anywhere. Nowhere. When it was referred to a single bench, did you lodge an objection? Is there any objection on your part that it should not be sent to a
single bench? Simply said that there are no question of law is involved.
It may have been terribly wrong. That's not the point. The point is, did you raise any objection regarding jurisdiction? Not being before a single bench because it is violative of L. Chandra Kumar or it is violative of 5(6) or it is violative of that judgment, this court says. Nothing. The whole premise is factually not there. There is no interpretation of statutory provision involved. It is a case to examine whether the proceeding is in accordance with the provision or not. That is all. Where is the issue of interpretation? Which interpretation has arisen?
You will kindly consider My lord, and my lord, another judgment I want to rely, my lord, regarding the provision of departmental appeal, my lord. That is the Supreme Court decision, my lord. That is also, my lord, the Constitution bench decision, my lord. My lord, that is also a 7 judges bench decision. My lord, I am relying paragraph 16. Paragraph the relating to the disciplinary proceedings to provide for an appeal against the order of punishment imposed on public servants. Some rules provided even a second appeal or a revision. The purpose of section 20 of the effect to the discipline and the introduction of the remedies available there under is a condition precedent to maintaining of claims under the Administrative Tribunal Act. My lord, that is a condition precedent. The administrative tribunals have been set up for government servants, the central and several states. Already such tribunals of the act for the authorities of the state. The law is going to the line laid down under section 20 of the Administrative Tribunal Act. In this background, if the original order of judgment is taken as the date when the order of action first for the purpose of Article 50 of the Revision Act, the date action is found to result. On one side, the claim is not date. On the other, if the departmental remedy available is not finalized within the period of limitation, the cause of action the judiciary become barred by limitation. So the grievances in the hands of the departmental officers take long time. Account of the fact that no addiction is ordinarily is but that is we are not considered to be governmental business or something. This absolute on whom power is vested in course of appeal and revision under the service must be put of matters as possible. Ordinary outer limit that will visit the system and keep the public servant away from the protected period of litigation. We are satisfied that to meet the situation as here, it would be appropriate to hold that arise when the remedies available to the public servant they can service to the redressal are disposed of. The question of consideration is whether it should be disposal of one appeal or the entire hierarchy of the reliefs as may have been provided. Statutory guidance is available from the provision of subsection 2 and 3 of section 20 of the Administrative Tribunal Act. There has been laid down. My lord, that section 20, my lord, has been quoted. Then your lordship kindly come to the paragraph 20. We are of the view that the cause of action shall be taken to arise not from the date of original adverse order, but on the date when the order of the higher authority where a statutory remedy is provided, interning the appeal or representation is made, and where no such order is made, though the remedy has been paid off 6 months of appeal or making of the representation shall be taken to be the date when cause of action shall be taken to have first arisen. If however make it clear that this principle may not be applicable when the remedy appeal has not been provided by law. Repeated unsuccessful representation not provided by law are not covered by this principle.
Yes.
So, my lord, the appeal, the 7th decision, my lord, that the statutory appeal is a condition.
Yes.
My appeal and respective submission, my lord, that was not considered, my lord. Even it was not also raised, my lord, according to the section 20 of the Tribunal Act, that ought to have, that was the duty of the tribunal to consider that. But that was not done. And my lord, finally consider what was the, I want to show just 3-4 lines of the charge sheet. My lord, that was if on the basis of a fake appointment letter, he was appointed and continuing his service, my lord.
Where is the
Page 33, my lord.
where is the statutory provision for appeal?
Yes, my lord.
Where is the statutory or the rule provision for appeal? Hmm. Hmm.
Page 356. That is also a judgment of the Honorable Supreme Court, my lord.
This is the second OA. OA number? No, no, the OA which you say could not have been filed without exhausting the appeal remedy. That is which OA? Regarding which OA you are saying that it could not be filed without exhausting the remedy of appeal? Which OA?
Second OA, my lord.
Number.
Number is, my lord, 1381 of 2021.
1381 of
1381 of 2013.
2013. Yes.
That was, my lord, disposed of on 23rd of May 2013, 2023. Challenge, my lord, being aggrieved, the railway file and review application. My lord, that is review application number is RA number 14 of 2023. And that was also dismissed on, my lord, July 2023. And, my lord, for a moment, kindly see page 33, my lord. I am not showing the entire charge sheet file.
Page.
Page 33. Initially, he was suspended. Thereafter, my lord, the charge sheet was issued.
No, what has the tribunal done? It has, by the order passed in 1381 of 13, what the tribunal has done?
That was, my lord, that was the second charge sheet. If,
Let
my lord,
us-
second charge sheet, it was, my lord, the entire.
Let us see the order.
My lord, prior to that, just two things, my lord. Page 33, my lord. That is the Sri Biplab Ranjan Sarkar, son of late such and such, was appointed through ANBT's letter number such and such dated 5/2/1994, which is a fake letter. Therefore, you are requested to suspend Sri Biplab Ranjan Sarkar and it should be followed by issuing SA5 with immediate effect. So, my lord, due to that fake appointment letter, he was, my lord, suspended, and on that basis, charge sheet was issued.
So what are you trying to submit?
My lord, I want to try to submit when, my lord, there is a serious thing is involved regarding the appointment, what the Supreme Court is stated. My lord, kindly see page 356. My lord. We have heard the learned counsel for the parties and perused the record. The charge against the respondent was that they done appointment without there being any genuine appointment. The charge was established after due inquiry. We are of the view that even if there was any procedural
Your brief has 4 page numbers. Which is the correct page? We don't know.
page 356 or 360. My lord, that should be, my lord, 365, my lord. 365.
You are referring to an order of which date? What is the date of the document?
September 11, 2017. At the bottom left hand side, my lord. $365, my lord. That is, my lord, the one page order of the Honorable Supreme Court, my lord.
Not 356, it's 365.
The Union of India, that appeal was referred by the Union of India, my lord. versus Dilip Bishwas. Leave granted, we have the learned counsel for the parties and peruse the record. The charge against the respondent was that they gained appointment without there being any genuine appointment. The charge was established after due inquiry. We are of the view that even if there was any procedural irregularity, there was no justification for quashing the order of the termination. Accordingly, we allow this appeal, set aside the impugned order and dismiss the writ petition filed by the respondents. And in my case also, my lord, that on the
So in any case where there is a charge of fake appointment letter, the termination should never be set aside.
my lord, when my lord, that was proved by the
What
disciplinary.
is this? What kind of submission you are making?
Yes, my lord.
You are reading a two-line order of the Supreme Court. What is the fact therein? Nobody knows. And you are saying that it becomes a proposition of law that any case where there is an allegation of false appointment letter, termination should not be caused.
Not merely allegation, my lord.
You have read the charge memo.
If charge,
So charge memo is only an allegation. You have read the charge memo and based on that you say, look what the Supreme Court says.
is also proved. Kindly see that.
So that you have not shown.
Yes,
What are you trying to submit? We don't know.
that was proved, my lord.
In any case where there is an allegation of,
Not I am submitting that, my lord.
that is what you have submitted. You have read the charge memo and you said, look what the apex court says.
My lord, the charge sheet is
You have just read it, page 34.
I'm showing, my lord, the order of the report of the inquiry officer, my lord.
Therefore, we asked you what the tribunal has done, you have not shown us. Whether the tribunal has set aside the termination or tribunal has set aside the charge memo.
Charge me.
Then why should we go into the termination?
My lord, before that, my lord, I want to show the fact, my lord, what was the charge and the inquiry of the report of the.
Yes, what else do you want to show?
My lord, kindly see page 68. That is
For what? What is that?
that is the report of the inquiry of.
Not required. It has not been interfered, not been looked into by the tribunal. Again, we are saying, what has the tribunal done? Show us first. Why should we go and examine every paper that you are placing? Whether the tribunal has considered, not considered, what is the ground on which the tribunal has set aside the order? You are not showing. OA number 1381, where is the final order?
Order of review, my lord, that is the last annexure, my lord.
Where is RBE 171? Show us. RBE 171 of 93.
That is the impugn. That is at page, my lord, 357. Not visible, my lord. page page
Three
that
fifty-four,
from page 355, my lord. 355, my lord. RB 171 of 1993, my lord.
yes. 355,
355, my lord.
we have to discontinue with this. Order is almost complete. Last page only. I've lifted my height. I saw it 2-3. Thank God. Enter line. Don't cross this. I put the petition. Oh. Yes, ma'am. May I submit? Yes.
Yes, ma'am. This is a case for only interest on delay payment of the gratuity, my lord.
Hmm?
Interest on the delay payment of gratuity, my lord. Is a case, my lord. The whether there is a delay on the part of the administration or the petitioner, that should be seen, my lord. In page number 10 to 13, my lord, the order of the president. In earlier occasion, the president's order was not annexed, for that is in supplementary affidavit has been filed and it has been annexed, my lord. Page 10 to 13, my lord.
25/5/21 order.
Yes.
25/5/21 order.
Yes. Yes.
25/5/20.
February and March, the supplementary affidavit has been filed.
Which order? 25/5/21.
25. Now, as per the order of February, within March, the supplementary affidavit has been filed. And as because the
You are referring to which order? President's order.
order 21, presidential order, 8 January 21.
8 January.
28 January 21, page number 10, my lord. Supplementary affidavit. Supplementary affidavit. Supplementary.
How this is relevant? The punishment order, come to the punishment order.
The punishment order has not been challenged, my lord. Punishment order has not been challenged. Only the delay interest on the gratuity payment. But whether the delay or not, my lord. Page number 13, my lord, the last para, my lord, page number para 9, my lord. It is clear. The period of alleged conduct, December 13, 2013, and date of issuance of charge sheet, 20th/7/2015, and the date of submission of inquiry, 23/2/2016. But the matter has been sent to the railway board after 4 years. And that is admitted fact by the railway as because the precedent date of receipts of the case. So there is a delay on the 4 years on the part of the administration, my lord.
All along you have filed 3 OAs. You have filed 3 OAs
Yes.
already.
Yes.
So all that issue is over. There is a punishment order. That punishment order says only 5% of monthly pension is to be withheld for 1 year.
That has not been challenged.
That has not been challenged.
No.
Then what interest you will get?
There is no order for curtailment of the gratuity, 5%.
Correct. So there is no curtailment. Then what is to be done?
There is a delay payment of gratuity.
Show us the provision that if there is no provision, then there is no, if there is an order
Yes.
passed in a disciplinary proceeding wherein you have not been exonerated,
On the pension, 5% pension curtail. And that
will you allow us to say something, or you will say in the midway whenever we say something?
Sorry, man. Sorry.
There is a punishment order withholding 5% monthly pension.
Pension.
The date of that order, prior to that or date of that order,
After
the DCRG was withheld under the provisions of the rule, that you never challenged withholding, or it was unsuccessfully challenged because it was withheld under the rule. The date of the punishment order, what is the date of the punishment order? 25/5/21. It is 25/5/21.
21 finally.
25 April May 2021.
As per the president order.
Yes, 25/5/21, the punishment has been passed. Now, once the punishment has been passed,
Yes.
the withheld gratuity, what is the consequence on the withheld gratuity? You tell us.
My case is, my lord, whether the delay on the part of the administration.
That is not
suffered by the
open.
petitioner, my lord.
That is not open to you.
The master circular is there, my lord.
That is not open to you.
Refer to the railway board.
That is not open to you. That all that you have already filed away and everything is over. Now only this punishment is there. After issuance of punishment within 3 months, the gratuity was to be paid to you.
That has been paid.
No, it has not. It has been paid even after delay thereafter.
As per Rule 10, my lord, if there is disciplinary proceedings, there continue that the punishment, the DCRG may be stopped. But the delay on the part of 4 years, admitted delay, 16 to 20, they have matter sent before the president.
Now it cannot be looked into. You should have challenged. You should have challenged when it was kept pending.
Circular is a master circular within 6 months, the retirement.
All right, you give it, we will consider. Nothing. You give, where is the circular? What are you relying upon? Which provision?
6 months, within 6 months, next page, next page. Underline there is also. 26 para. No, ওটা না। এটি মাস্টারটা। মাস্টার।
What is your date of retirement?
31/7/2015, my lord.
31 July.
After the 7 days, charge sheet was given on 7 days before, my lord.
We are asking you what is the date of retirement?
Date of 31st, 20 dinner, 31st 7, 31st 7, 2015.
31st July
July.
2015.
15. Due time the DA was completed, my lord.
Yes, give the judgment.
76 of 91. It says that yeah, has been paid in July. That 3 4 months you can get. Is judgment with perfect. Yes.
Judgment is Supreme Court judgment.
Again. National Development. Gratuity Act will
How this will apply to you? You give any judgment.
Just delay payment on the delay.
Every case of delay will be covered by this judgment. What is this? They have been appearing. Hmm. I don't know. Submissions have been advanced on behalf. See. Let bring him on side.
Lord, see, my lord, I'm praying for lordship 2 weeks time to file the affidavit in reply, my lord. We have
2 weeks.
10 days, my lord, if your lordship.
Earlier time has been granted.
Earlier, my lord has directed filing the affidavit within 3 weeks. My lord, for the first time, I'm seeking extension, my lord.
Oh, so therefore it has to be
No,
granted.
my lord, I am not. This is about not. We are at fault, my lord.
2 weeks.
Grateful.
Time is allowed for filing a reply.
My lord, item number 24, my lord, I am for the respondent, my lord.
Can I submit it to the rejoinder?
You want adjournment and to submit the rejoinder also. Submit it tomorrow.
My lord, item number 24.
You have served the rejoinder. He is seeking not today. Let it come. He is appearing, sir. He is appearing virtually.
My lord, there was no order at the last occasion, my lord, there was no order and he didn't ask for giving a rejoinder, my lord. On the last occasion, I had completed my submissions and on the earlier occasions, my lord, the petitioner already completed his submissions, my lord. Kindly see the last order, my lord.
Then why you are filing? Let it come tomorrow. We'll see.
All right.
Much obliged.
There is ill, my lord. He is
Right, not today, we have given.
My lord.
26. And for the respondents.
Can be done. Every day nowadays we are getting,
I can.
not today.
Not today. 27.
My reply, find the reply. Yes. It's short.
Eleven.
आपण बोलच्या क्लिक
Order. Item number 28. 29.
I appear for the petitioner, but I appear for the petitioner in item number 29. No, it's not,
For the first time.
not coming for the first time, Lordship. But on the previous occasion,
The respondent has already appeared.
yes, he's appeared. There was a contempt proceeding before the tribunal. Your Lordships have also intervened. So, but then they have not.
Not today, let it be. Let's see what it is on Friday. Huh? Nobody is appearing. No adverse order. So there is absence.
Item number 30. 31. 32. 33. 34. 35. 36. 37. 38. 39. 40. 41. 42. 43. 44. 45. 46. 47. Monitor 48. 49. 50. 51. 52. 53. 54. 55. 56. 57. 58. 59. 60. 61. 62. 63. 64. 65. 66. 67. 68. 69. 70. 71. 72. 73. 74. 75. 76. 77. 78. 79. 80. 81, 82, 83, 84, 85, 86, 87, 88, 89, 90, 91, 92, 93, 94, 95, 96, 97, 98, 99, 100, 101, 102, 103, 104, 105, 106, 107, 108, 109, 110, 111, 112, 113, 114, 115, 116, 117, 118, 119, 120, 121, 122, 123, 124, 125, 126, 127, 128, 129, 130, 131, 132, 133, 134, 135, 136, 137, 138, 139, 140, 141, 142, 143, 144, 145, 146.
I've got a in this matter. Petitioner. Lordship, we have filed a substitution petition. The defendant has died. 146. Other side has.
As the petitioner has done.
They have not appeared. Huh?
146, 154 of Puji.
Yes. Ready.
We got about 5 over.
Terminal, no? Without against nine.
And one of Puji. One and one to that. And I do.
Lord, 146 can one up to 25. One. Lordship. Lordship, in the meantime, the respondent had died.
So that's why we have filed appeals for the substitution of the wife. Lordship. Lordship,
What relief the tribunal has allowed?
regarding the payment of the in respect of the disability pension, we have already given the 50%, but they are
Armed Forces, AFT.
yeah again came with the appeal against that order.
Huh?
Against the said AFT. We have filed
Appeal or writ petition?
a writ petition.
Every order of the AFT you challenge in a routine way.
Very simple differences between the facts and the law, because they are the disability patient we are giving, but they are claiming 80%. In our rules and regulations, we are only give the 50, not we can give the 50%. So this is the main.
What was the disability?
Lordship,
Anterior pivot ligament.
no, there was the incident which was not in the game of the force. He was voluntarily playing somewhere and he has got some injury in the legs, right legs. No?
Right.
He injured himself in some sport.
Yes.
Right leg.
Voluntarily he was playing somewhere, volleyball or football. So he has so if you are disabled in our forces game or sports, then we can give the 80%.
So there is a locomotive disability. What percentage?
In our 50%, they are claiming 80%.
No. What is the extent of disability? Not the disability pension.
20%.
20%. And that is certified by you.
As a medical board. Medical board.
By you. Where is that certification?
Lordship, Annexure E, page number 49. Lordship, please come to the page number 58.
Just give us 2 minutes. What is the date on which he has sustained the injury?
2009.
28th January. Where is the injury report?
Lordship, please come to 56. 55 is the opinion and 56 is the complete report is there. And complete report is on 58, Lordship.
পিছনে ভাইয়ের কোর্সটা ঠিকঠাক আছে কিনা পাম্প ছাড়াই জল তুলতে লাগছে চশমা স্প্রে মেরে বলবি লাস্ট
What is the date of this document? This is of 2019. We are asking you, where is the report of 2009?
Lordship, page 58.
This document starts at page 54. At the bottom of page 54, you will find the date is ascribed 5/11/2019. We are asking you that there is a supposed to be injury report of 28/1/2009.
The injury report is different. That is the 19, 9, 28, January 9.
Correct. Where is that?
Page 56.
No, that is not the injury report. That is not the injury. Either it is 28 January 2009 or 17 March 2009. These two documents, you please see page 56. The date of origin is mentioned as 28 January 2009 and date of initial AFMSF is 17 March 2009. These two are the contemporaneous documents. Where are these documents?
further instruction?
No, it must be there. It must be there in the book. So he says while practicing football in the service, he has suffered the injury.
Correct. But when the service was it voluntary playing for the outside from the different.
Where is this? Where have you said this?
Exactly. We are not like if any fourth person is playing in our.
Where have you said that he has suffered the injury playing football outside the service? Where have you said this?
It is committed as per the findings reported in the report of accidental and self-inflicted injuries officer dated 3/36/29. The action in question is clearly stated to have occurred on 28/1/29. These officer documents being contrivances in nature and prepared by the competent military authorities. Serves as a reliable and authentic record of the actual date of the incident. After the incident, he continued his service to the 19th.
So there is nothing. That is what we are saying. You have not said anywhere that he has suffered it outside. You are only giving the date. That's not your case. Unless that is your case, how can you say not attributable? That's not your case. We are looking for it. We have not found it anywhere. That is a different thing. You said he has suffered it and he was playing for somebody else outside the service. That is not state.
I beg your pardon, Ashok. What our contention was, this sports that he was involved in at that point when he was playing it, it was not directed or not advised upon by us.
Where is this statement?
Your Lordship, if we come to the initial incident report,
Yes,
incident
that is what we are asking for. 28 January 2009, or there is some report of 17th March 2009. These two documents.
Your Lordship, if you could kindly come to page 44. This was the first report that was submitted after the accident had occurred.
No, this is 10 years after the accident occurred.
Your Lordship, this was the incidental report that had taken.
Madam, read the bottom left corner of that page. There is a date mentioned. It is of 2019. The accident occurred in 2009.
Your Lordship, if you
Please read the bottom left corner of page 54.
Your Lordship, I apologize. I'm talking about page number 44, Your Lordship. I apologize. My page number 44, if you could, Lordship, just indulge for a second. Annexure C, Your Lordship. That this is the first incident report that was recorded. This was done by
There is no page 44 in my brief.
Annexure C.
Please have a look. After 42, there is page 46. Give us. We are adjourning. No, we are adjourning it for the day. Give us. Go through that brief, see if there are any other pages wanting, and you give the pages. The pages being referred to. Which day? No, this file just. Oh, it's not in the file. Oh, that's not in the file. Okay. You want us to sign this?
148,
Yes, not.
149, 150, 151, 152, 153, 154, 155, 156, 157, 158, 159, 160, 161, 162, 163, 164. So you checking that. 165, 166, 167, 168, 169.
Yes, 169, I appear for the petitioners. Some urgency is there. Can it be fixed on 10th November, subject to your lordship's kind convenience? 10th November.
Even better, it will come only day after tomorrow.
Never reach. Unless your lordship fixes the matter, it will never reach.
Somebody is appearing for the respondent.
But we have served. This is a fresh motion from the West Bengal Administrative Tribunal.
No, is somebody already appearing for the respondent?
Nobody has entered appearance as yet, but we have served. On the next date, definitely, or we can again intimate the other side. 10th November, if your lordship keeps it,
As prayed by the learned advocate. Please give an appearance. He will not give the appearance, you will give the appearance. Yes.
One 171, 172, 173, 174, 175, 176, 177, 178, 179, 180, 181, 182, 183, 184, 185, 186, 187, 188, 189, 190, 191, 192, 193, 194, 195, 196, 197, 198, 199, 200, 201, 202, 203, 204, 205, 206, 207, 208, 209, 210, 211, 212, 213, 214, 215, 216, 217, 218, 219, 220, 21, 22, 223, 224, 225.
Before, but my the other side was here, but there was only a notification that was to be submitted, filed before your lordship with regard to the scheme for compassionate and seniority. This matter has been heard by your lordship 4 occasions.
Friday, we'll take it on.
Grateful.
My learned friend is here, my lord. That matter.
Friday.